This is Dr. J. Kent Gregory, and welcome to part three of chapter three, uh, the chapter on litigation. And this will be our final part to the discussion of this chapter. So, statute of limitations and affidavit. So, a defendant may file a motion to dismiss based on the statute of limitations. So, what does this mean? If a long period of time has passed since the incident in question and the filing of the lawsuit, the statute of limitations, a defined time limit under which a legal action must convince or be forever barred, and then toll, a temporary halting of the clock and calculating whether the statute of limitations has run out. And then in support of any motion, a party may submit an affidavit. This is a sworn statement a statement in writing made under oath, and it serves as an effective way for parties to tell their side of the story to the judge during pretrial. Um, Once pleadings are filed, litigation moves into the discovery phase. So, what is discovery? This is the method used in civil and criminal cases to obtain information about each party's case. It's designed to prevent trial by surprise, where either side suddenly produces evidence that allows it to win the trial. And this is typically the most expensive phase of the trial process. During or after discovery, parties may make a motion for summary judgment. And what is summary judgment? This is a judicial order declaring a winner on the merits of a case. So, types of discovery. Uh, Interrogatory, so these are written questions posed by a party to another party during discovery. Request for production, so a party can request the other party to produce written communications. And then spoliation is another concept related to this, and this is destruction of key evidence in a trial. Uh, so we've without going into any detail about that, but you can imagine how that would manifest itself. Uh, Other types of discovery, requests for admission, a set of statements posed by one party to another for purposes of having the other party admit or deny the statements, thus to narrow the scope of facts to be tried. Um, Deposition, this is a statement by a party or witness made under oath. And another related concept is to impeach. And this means to challenge the credibility of a witness to tell the truth. So here are some key takeaways from what we've been discussing. So litigation commences with the filing of a complaint by the plaintiff. Uh, Frivolous cases are prohibited in litigation, but it's relatively easy to argue that a case is not frivolous. The defendant files an answer to the complaint. Uh, Most civil and criminal cases must be brought within the prescribed statute of limitations. And during the discovery phase of litigations, parties share and exchange information about each other's cases so that neither side is surprised during the trial. At least that's how it's supposed to happen. Um, so the selection of jury for trial, after discovery, the case is scheduled for a trial. So this implies that there are genuine issues that parties cannot resolve, and both sides are determined to see their side win. So the first step is to seat the jury. So there's a process known voir dire, and this is the questioning of prospective jurors. So it often begins with jurors filling out a written questionnaire, and then attorneys in turn quiz or question each potential juror. And if an attorney does not like a juror's response, that juror may be excused from serving the particular case at hand. Challenges faced by a potential juror for cause. So a challenge to a prospective juror for a good reason, such as bias, and peremptory. This is a challenge to a juror without giving a reason. So the attorney does not give a reason. So some key takeaways here as we wrap up chapter 3 on litigation. So the process of selecting a jury is called voir dire. Each side is permitted to question a potential juror and excuse that juror for any reason through a peremptory challenge or for a good reason through a for cause challenge. Trial begins with opening statements. The next witnesses are called to provide the testimonial evidence. The side calling the witness conducts what's called a direct examination, while the opposing side conducts a cross-examination. After all witnesses are called, the parties make closing arguments to the jury, which then deliberates and applies the law as outlined in the jury instructions. The burden of proof in a criminal case is beyond a reasonable doubt, while the burden of proof in a civil case is preponderance of the evidence. So a jury's verdict must be converted into a legal judgment by the trial judge. Once all appeals are settled, res judicata prevents the case from being tried again. So that brings an end to Chapter 3, the chapter on litigation. Thank you much.